Hello, everyone. Welcome to week 7 of the Summer Grant Writing Workshop. I'm filling in for Dave today. Today's guest speaker is Michele Tyrpak. She's the director for the Technology Transfer Office here at USF. She provides leadership and management for the Technology Transfer Office by driving licensing, patents, and startup activities for the commercialization of the USF intellectual property portfolio. She also enables coordination among university researchers, administration, outside counsel, external parties, and government agencies. Prior to joining USF, Michele served as the Senior Intellectual Property Counsel with the Lubrizol Corporation, where she managed a global patent portfolio in the life sciences and polymer fields. Michele holds a JD from Cleveland Marshall College of Law, a BS in Medical Technology from Cleveland University. She'll be also completing her MS in Pharmaceutical Nanoscience here at USF this summer. So congratulations. And so now I'm going to turn it over to Michele. Thank you.
All right. Well, good afternoon, everyone. And thank you for joining me. And I'm going to talk today about intellectual property and how it works in with your grant writing responsibilities. So, I'm not here to have everyone learn to become a patent attorney. It's a lot of intellectual property itself can be, pretty dry topic as anything in the legal field. So I will do my best just to give you a brief overview and then how it applies to your grant writing. So I'm going to go ahead and share my screen. And bear with me here because as many times as I do this, it's always an effort. Okay. And I'm sorry because I have multiple screens on, so I need to share the appropriate. I apologize. Goodness. Second here and see if this works. All right. Okay. Can everybody see okay and hear me okay? Just give a thumbs up.
We can hear you, Michele.
All right, great. Thank you. All right, this may not be the best presentation mode, but we're going to work with it. Okay. So what I want to talk about is how, IP is connected with your grant writing, and just go over initially some of the IP basics, and then grant requirements and how that works with your IP. So we'll touch on the Bayh-Dole Act a little bit and how that affects federal grants mainly. Data sharing plans you might see in the grant proposals. If you are applying for SBIR or STTR grants, especially if you decide when you invent something, you want to be an entrepreneur and form your own company, if you have interest in that, and where IP fits into that, as well as budgeting. And then A very large concept that I will talk about is protecting your IP before you publish. Okay. So first we're going to talk about, and I'm sorry, this has the notes on it, about the IP basics. And many of the questions that people are wondering about, the various different kinds of IP, as well as who owns the IP that you develop. Okay, so the four pillars that we usually talk about with respect to intellectual property, four different kinds. All right, mainly we have most people are familiar with patents. Okay, patents protect things like compositions of matter. They can protect designs. Actually, there's a specific type of patent for designs. It could be a method of doing something, a method of manufacture, perhaps, or a process or a way that you do something. And the main two requirements in order to obtain a patent is that it has to be novel. So no one else can have done it before. If it's been published about previously, whether it be from a scientific publication or if it's perhaps it's a already granted patent or a published patent application, then it's not novel because people already know about it. The other requirement is that it be non-obvious. When we talk about whether an invention is non-obvious, what we refer to is whether an examiner, when he's looking at your patent application in the patent office, he could combine different teachings from various publications. So maybe he will take a patent application and then he sees a scientific publication and he combines multiple things and he says, based on the teachings from these various documents, one skilled in the art, so someone who is uh, uh, um, that has the same skill set and knowledge that you might, they are able to come up with your invention. So it is obvious. Okay. And then, of course, your invention has to be useful. A utility patent application is good for 20 years from the date that you actually file the application. A design patent, on the other hand, is 15 years from your filing date. So in technology transfer, we don't see too many design patents, but they do come across our desks every once in a while. Another form of IP protection that most of you are probably familiar with is copyright. And copyright has to deal with works of authorship. So it's something that it can be a form of expression. Some examples are books, plays, could be a photograph, the notes that you might be taking right now on the workshop here. As soon as you write them down, you own copyright in that. Okay, so as soon as something that you create is put into tangible form, you actually own the copyright in that. The difference being that you can actually register your copyright with the U.S. Copyright Office. And that provides you some extra protections that you might not get if you just say, I created this, here's my notes, and so I own it. Doesn't give you the same protection as a copyright that you register with the Copyright Office. Okay. Another form of IP protection are trademarks. So trademarks are things like, just they could be the name of something. So for instance, it could be Coca-Cola. We all see the signature Coca-Cola on bottles and things like, and there are different types of products. That is a trademark because it associates that good with a certain brand or company. Okay, when you see that script Coca-Cola, that it belongs to the Coca-Cola company, okay? A trademark can also identify the source of the services that are being provided. So a trademark protects both goods and services. A trademark is good for as long as you continue to pay for the renewal fees. So as long as you are using it and you're making the payments to renew that mark, it can last forever, essentially. And then finally, trade secrets. So trade secrets are protectable information. It's usually kept confidential, and it can cover essentially anything. Could be a composition of matter. For instance, the Coca-Cola composition is a trade secret. It's never been patented. It's not, written down and made public. And so it is a trade secret. It can also be a process, so maybe it's a method of doing something that you don't want anybody else to know, because if you put something in a patent, you are essentially telling everybody how to do something. You're telling them how to make that composition of matter or how to do that process. And under a trade secret, you don't make that information publicly available. Okay, and a trade secret remains a trade secret so long as you keep it secret. And there are certain rules that you have to follow in order to prove that you're doing that in order to maintain a trade secret. Okay, I'm going to stop here, and I'm going to tell anyone, if you have questions as I'm talking, please, raise your hand or put them in the chat, and Candace will let me know that they're there. So any questions so far about the 4 main types of IP and the differences? Okay. Okay. So we have a question. Okay.
So it says, what are some of the requirements to maintain a trade secret?
So you have to have a documentation, that you're maintaining this as a trade secret. When you have to have confidentiality agreements in place with all of, so for instance, if I use Coke as an example again, all of their employees probably have confidentiality agreements in place. So you have to be able to prove, that you are maintaining this as a trade secret. Okay. So what can and cannot be patented? Went over this a little bit previously. So obviously you have to meet the 3 requirements: novelty, non-obviousness, and usefulness. So if it doesn't fit any of those things, you're not going to be able to get a patent. And it can be, like I said, it can be a method of making something, a process or way of doing something. It's a new composition of matter. It's a new device, a formula, or it can be an improvement on things that are already existing. Okay, those are all patentable subject matter. Things that are not patentable. So a lot of things being developed right now with AI. There's a lot of discussions on whether those things are patentable. So right now, the advice is, if you're totally reliant on AI to come up with whatever you invented, AI can't be an inventor, and it's not patentable. You cannot patent laws of nature or things that already exist in nature. So naturally occurring substances. So if we have a faculty member here, for example, at USF, that pulls up, he does a lot of diving, and he pulls up a lot of things from the bottom of the ocean. And then he isolates, maybe it's a plant or something that secretes some sort of enzyme. The enzyme itself is naturally occurring, and so it cannot be patented. You could patent a use of that enzyme for maybe he finds it useful in treating a disease. So you can patent that use, but not the enzyme itself. Okay. And also things that are obviously already publicly disclosed, that's going to be issued because it's prior art against novelty or non-obviousness of your invention. Talk a little bit about a provisional versus a non-provisional patent application. So a lot of times what we do here at USF, when we get disclosures in and we decide that we're going to file for a patent application on it, is we will file what's known as a provisional patent. Okay. A provisional patent application doesn't have to contain any claims. So that's at the very end of your patent, you're claiming exactly what your invention is. We don't need any of that. It can be something as simple as the presentation that you're going to give the next day. So it's just it gets you a filing date, and it prevents others then from filing what may be something very similar. Because if you're the first to file, then you have priority. So provisional, very, very simple. It could also be a full application and you call it a provisional. But it's a lower cost and it's a placeholder. It gives you that filing date because that's important. If you're going to go present then the next day, we want to get an application on file before you do that, to preserve novelty. And I'll talk a little bit more about that later. It also, so then within 1 year, that provisional application, it never gets examined at the patent office. It just sits there, okay, for a period of 1 year. And before that application expires at that 1 year period, we're going to decide, do we want to file a full utility application? Maybe you've done a little more research and you have data, and the outside counsel, and I apologize if you hear my dog barking in the background. But if you have more data and information that you can use to support your application, then our outside counsel that we work with, our patent attorney, can include that information and give a much more, what we call much more robust patent application than to file. And that needs to be done before the end of the 12-year period. So as well as if you're filing in the US, you would do that. And then that 1 year period is also when you decide, am I going to enter patent applications in other countries? That's your deadline for foreign filing. Okay. So things for you to think about when you have an invention or you are creating, something that might be copyrightable. This just shows a little bit about the different types of protection, how long they last, and what they cost. So a patent is usually going to be your most expensive avenue. I will say that I think on average, from filing to actual issuance of a patent can cost from, I would say, $25,000 upward, depending on the complexity of the invention. Okay. So you have this invention or you have this copyright. Who owns it? So generally, if you are employed, if you're working for a company or you're working for a university, the rule is that if you're using resources of your employer, or at USF, it's not only if you're using our resources, but it's also if it's related to the field of research for which you are employed at the university, then the university can assert an ownership interest in that invention or copyright. Okay. So I can guarantee that anyone who is employed by a university here as a researcher, you should be familiar with the university's intellectual property policy. We all have one, okay, and it will explain what that university will assert an interest in, and what they don't as well. And then the IP policy also will usually tell you about if your technology then is licensed, or your copyright is licensed to an outside party, and there's revenue generated under that license, how that money will be distributed to you as an inventor. Okay. So the IP policy requires you to disclose your innovations to your technology transfer office. Our office then looks at two things. They will look at, is it something we can protect with some form of intellectual property? And also, does it have commercial value? So can it be scaled up? Is it something that is bigger, better, faster, cheaper, stronger than what's already out there? Okay. We will look at the market, what the potential is. And so those two things, if we decide they're both positive, then we will move forward with IP protection and marketing of the inventions or copyrights to outside parties in order to further develop it to a commercial product. Okay. So if it may be decided that, the tech transfer office decides, no, this isn't something we can protect, or we don't think we're going to get a good chance, or we have a good chance of getting protection on it, or it's something that it's not of interest in the commercial market necessarily. Maybe it's going to be too costly to scale up, that it's just a business decision that is made. So don't be offended if your tech transfer office says, we're not going to move forward with this. Okay, it has nothing to do with the fact that your science is bad, or, it's a business decision. And your tech transfer office should be, giving you some information on why they would not move forward. But at that point, we can release the rights back to the inventor. You may decide to move forward with it yourself. And that's something that you can do. So, make sure you're familiar with your institution's IP policy. Okay, so now we will get into a little more nitty-gritty about grant requirements and how that fits in with your IP. And I'm going to pause again at this point to see if anyone has questions on the IP section itself. I know it's Friday afternoon, and you guys are awful quiet, though. Okay. Okay, so how many people are familiar with by the Bayh-Dole Act and what the implications were? Show of hands. Okay, a few people. All right, so the Bayh-Dole Act came about in 1980. Prior to 1980, under federal grants to universities, the government retained ownership in any intellectual property that you might have developed. Okay. So we all know the government really isn't in the business of developing IP to a commercial product. And so Senators Bayh and Dole made the argument that universities should be able to retain ownership in federally funded IP. And that is how the Bayh-Dole Act came about, and actually was the start of technology transfer. Okay, because that's what our offices do. As faculty members disclose to us, and we elect to retain title, and then go about with IP protection and licensing. The only reason we're allowed to do that is because of the Bayh-Dole Act. So there are some requirements under the Act. One of them being that when something is disclosed, we have a certain period of, our office has a certain period of time to let the government know, hey, here's an invention that was created under this grant. Okay, we are going to elect title. So we're going to assert an ownership interest. Okay, and then it becomes what's called a subject invention. We have to file and report under iEdison about the invention and what's happening with it. And then we also have to allow the government to have a non-exclusive license, royalty-free, to practice the invention for government purposes. And they also get marching rights in certain cases. So marching rights refers to when the government can come in certain instances. For instance, if there's a public health issue. Another instance is if there's a time of war. So there's something about this invention that would be useful in those instances, and the government can come in and require someone that you've already licensed that technology to. So an outside, your licensee then is required to give a compulsory license to everybody else to be able to, well, let's say if it was the COVID vaccine, if that had technology already been licensed to a party, then they would have had to give license to everybody else to make it. Okay, the marching rights have never been practiced so far, but it's just a wait and see. We never know. So just something to be aware of. Another thing to think about when you're doing federal funding is data management and sharing plans. So I have a specific instance here, under NIH's policy. All NIH funded research which generates data, you have to submit a data sharing plan, and most federal agreements will have language in them that say that they want your inventions and your work to be published, and that's all fine so long as if you're intending to protect it, or the university is intending to protect it, that we do that before there's any publication. Okay, you'll also see things like IP management plans. So the government wants to know, if you invent something, what are you going to do with it? Okay, they don't want to fund something that's just going to sit on a shelf somewhere. So what is your intent with protecting the IP and then commercializing it? Those are good cases where if they ask for an IP management plan to work with your tech transfer office to put one of those together. It's pretty simple. I'm sure TTO employees are familiar with them. So if you tell them that's what you need, they're happy to help. Okay. And then lastly, coordinate sharing versus protecting. So, there may be instances where you've created something that isn't necessarily something that you want to protect. You want to make your software open source, and that's okay in some instances, but make sure that you're letting your, again, tech transfer office know. Okay. Okay. This is something, a takeaway for you to use, just a checklist before you, um, when you apply for a grant or you have a grant and you invent something, have I disclosed my invention to the tech transfer office? Do I have a IP management plan or data management plan? Do I need it? So would I need to work to get that in place? Am I familiar with the IP and data rights and ownership according to whoever the sponsor or funder is? Different funders have different requirements. So don't assume that, I've read one, I've seen one, I've seen them all. Okay. Um, have I allowed for budgeting of patent costs? There are certain cases where that patent costs are allowed under the budget, and the tech transfer office is very grateful if you include that in your budget, because otherwise, the university isn't getting reimbursed for those costs unless and until you get to a license agreement. And then, is there a public disclosure? Have I, am I going to make a presentation? Is there a poster and am I putting an abstract out there somewhere? And if you're not sure, talk to the tech transfer office. I would rather get those types of questions than the faculty not do it. And then we're in a situation where they tell us after the fact, and now we're limited as to what we can and can't do. Okay. And I feel like I skipped a slide. Yeah, okay, I'm gonna go back one here. Special cases and budget reality. So, I mentioned about patent costs. In certain instances, they can be included, and that is normally under SBIR and STTR applications. They will allow up to a certain amount for reimbursement of patent costs. And again, that usually comes into play when you are, you've decided to be a founder of a company, and your company is then going to apply for those types of grants. But generally, federal funding doesn't allow for coverage of patent costs. So just something to keep in mind. Okay, so I'd say talk amongst yourselves, but since you're all over, um, I'd like to spend a couple minutes if anybody has had any experiences about, have you ever presented or published before thinking about IP, and what was the outcome? Really, nobody's ever had an instance where they presented or published and then went to the tech transfer office? So I'll tell you what happens. Okay. Um, we appreciate the fact when someone comes to us and they say, I'm giving this presentation even today, later today. I think I need to do something. And so we will ask, can you give us your presentation and any other supporting materials that you might have? Or they might say, I have a manuscript that's going to publish. I submitted it, publication date's coming up. Okay, give us your manuscript and we will take it. And that's when we file that provisional patent application, because all we're going to do is take those presentations or manuscripts, attach a form that we're required to from the USPTO, and file it then, and we get a filing date. Okay, so if you don't do that, what happens is you forfeit any rights to protect your IP in foreign countries. Okay, the US is the only place that has a 1-year grace period. So if you present or you publish without filing an application first in the US, you have 1 year from that date that you presented or published to file an application. But everywhere else in the world says, nope, you're out of luck. You have made a public presentation and you have lost your novelty in that invention because now everybody knows about it. And whether that's the case or not, the thinking is that even if it's just one person that now knows about it, it's public. Okay. So very important to keep that in mind. Yeah. And I've kind of touched on this a little bit already, but these are just some examples for you to keep in mind when you're thinking about, applying or presenting a journal article, a preprint. So if you put a little abstract up on a website somewhere, it's a public disclosure. If you go to a conference and you give a talk and you haven't filed a patent application yet on what you're presenting, and you think it might be, worth patenting, you gave a public disclosure. Also, and I used to see this when I worked for a company, we would have salespeople go out and offer something for sale that we had not yet filed a patent application on. And that was a public disclosure. And so that salesperson, forfeited the company's rights to file a patent application in foreign countries. So not, made for some very unhappy business people. So you just, keep this in mind. It's something to be aware of. Okay, we already covered this, the 1 year grace period in the US versus the rest of the world. Any kind of publication or public disclosure, you've destroyed absolute novelty. Okay, so just to talk about, an example, when a researcher presents at a conference and then realizes after the fact that it happened. There's a lot of, I guess, kind of, conflicting issues when you talk about, especially in academia, because academics are encouraged to publish and disseminate their work. And so when you have somebody else telling you, the tech transfer office says, no, don't publish yet, because we need to file a patent application. And oftentimes the patent application takes a little bit, to write it. Sometimes it takes, 2 or 3 months, because it's a lot of information. That those are conflicting issues. And it's not always easy to resolve. So, just again, keep it in mind. Okay, this is a specific example, a little different about what happened in the case of the University of Rochester and a pharmaceutical company. So the University of Rochester had invented a pathway for an enzyme that had to do with inflammation, especially in arthritis and any kind of joint issues. And they filed a patent application on a method of treating inflammation, by administering this enzyme. But they failed to actually identify what the treatment actually was. So they said, we're going to treat you with this compound, but they never said what the compound was. Okay. So they then went and sued, the university sued the pharmaceutical company And the court said, well, nope, sorry. We're going to side on with the pharmaceutical company because your patent application, while you talk about a method of treating inflammation, you don't say what you're treating it with. And so this is important because sometimes we get disclosures from faculty that are too early. Okay, we'll get a disclosure that sometimes it's just at the idea stage. I think I can treat inflammation, but I don't know yet what the compound is. Well, in this case, the tech transfer office just took it, and they went ahead and filed an application. It was too early. Um, there may not have been data yet to support that conclusion. In this case, there obviously wasn't even a compound to show that it actually, could do that. So it's a matter of weighing when to disclose, and how much information you have. More information is better, but don't wait. Don't wait too long either. Okay. Don't wait. Don't feel like I have to have a prototype or I have to show that this works exactly as it needs to. Then you're probably too late. Okay. So if you're not sure, again, talk to the tech transfer office. I know I'm saying that a lot, but it's important. And we can make the decision, yes, you have enough information, we should file now, or no, you don't. And we work with our outside counsel also to make that decision. Okay, something to be aware of. Again, this just goes back over, I have a result and I have a deadline coming up. What do I do? File first. Okay, always file first, then publish freely. Theses, dissertations, and embargoes. So this is something else we run into when we have PhD and master students, and oftentimes they develop an invention during the course of their research, and now they're going to give their presentation for their master's or PhD, and they don't always tell us. So in that situation, make sure also you're disclosing that to your tech transfer office because as graduate students, it is likely that the IP policy covers you as well. It's not just the faculty, and permanent employees. And either we can, there can be an application filed in advance of the presentation, or your dissertation can be embargoed. So I know at our university, we can tell the library, because those are the people that put it online. This needs to be embargoed it's usually for a year. And then that gives us time, if at the last minute we didn't know about it, we can work with our outside counsel to prepare a patent application. So again, just something to, keep in the back of your head. Okay, so the three big things to remember: disclose early, but not too early. And if you're not sure, ask the question. File before you present or publish, and then read the IP terms in your grant applications and proposals. I know you have help with that. Again, a lot of times the tech transfer office reviews those IP terms in proposals. I know our office does, and we will provide comments, hey, this says this, you gotta watch out for that, or you gotta do this, just so you are aware, and then that can be managed. Just an example, some places for you for information if you have questions. Obviously, I've said tech transfer office way too many times, but we are here to help. This is our bailiwick, and what we're experts in. So we are here to help you. A lot of institutions have a invention disclosure portal right online. So I know we call it an inventor portal. Whenever someone needs to disclose something, they can just click on the button, they fill out a form, and it populates our database, and that's how we know to start a review. So we try to make it as easy as possible for our inventors. The USPTO and the World Intellectual Property Organization, awesome resources. They have all kinds of information and resources for inventors. Whether you're an expert or not, they are there to help you. And then iEdison and funder policies. I wouldn't worry too much about iEdison. There's usually people dedicated to that in your tech transfer offices. But just know that it exists and that it needs to be used to report, federal inventions for those types of grants. All right. And so I am open for questions and discussion about anything I've talked about or anything I haven't talked about related to intellectual property. So I'm willing to answer.
There aren't any questions in the chat just yet, but we can give it a few minutes.
Hi, Michelle. I'll start you with a
Hi,
question
Ross.
here. So more and more frequently, we're seeing researchers working with external partners on their work. Could you say a few words about how to protect IP, both the researcher's IP and the external partner's IP, when working collaboratively on research projects across institutions, and conversations that need to be had about these kinds of presentations and disclosures to avoid accidentally giving away your rights?
Yeah, so when you say external partners, just other universities or industry or just anybody in general?
I mean, I'm seeing all kinds of, maybe somebody in chat has a more specific example, but I'm seeing collaboration with pharmaceutical partners, and those, they're going to protect their own intellectual property, obviously.
Right.
But, I'm thinking more along the lines of like, educational technology, working with the local school board and, community partners and things like that. Yeah, military research.
Military
That's
research
a whole.
labs. Yeah. Yeah. So each one is different. Working with another university is usually done under some type of collaboration agreement, and that will have IP language in it. I would say amongst universities, the standard IP ownership follows inventorship. So if you invent it at your university, then your university owns it. If they invent it at their university owns it. And if you jointly invent it, then both universities own it. The federal government, obviously, they will allow the university where the work is being done to retain ownership with a non-exclusive license back to them for the government. And that's how federal labs kind of fall under that as well. Foundations, I would say some of them they'll try to retain ownership. But I also see, if you say, because what happens when another party says, I want you to do this work and we're going to own the outcome. That is what we refer to as waiving IP, and it's also a work for hire. So, they're their position is that we are paying you to do something, so we're going to own whatever you do. And as research universities, we argue we don't do work for hire, we do research. Okay, so we will try, and usually successfully, to make that argument and just say, well, we're going to retain ownership, but we'll give you the option to enter into an exclusive license if you want it for commercial purposes. If they want it for non-commercial purposes, then we're okay with that. But we don't want you to use our stuff so that you can go off and commercialize it, and make money, and then we get nothing. Okay. Um, Foundations, we will give non-exclusive licenses for royalty-free for purposes of them fulfilling their nonprofit mission. Okay, so it's all a matter of semantics as to what you're giving, but the university tries to retain ownership. It's not always successful, especially with the big pharmaceutical companies. We're giving you this money to do this clinical trial. We're giving you the drug to do it with. We want any IP that comes out of it. And we can sometimes narrow that a little bit, that it's not just a broad word, you get to take it all. We try to narrow it, but and having come from industry, I see their argument because they're spending a lot of money, to develop something. Yeah, they're going to make a lot of money from it. But if you look at the big picture, this is just my opinion, I think if you make an improvement to their drug while you're doing this trial, I think they have the right to own that. But, you know, that's just my opinion. So does that answer your question? Does that help?
It does. Thanks. I think I learned that I need to speak to the technology transfer office about the specific instance.
There's a question in the chat from Michael. It says, are there significant differences protecting intellectual property in humanities based research in comparison to scientific research?
Um, that's a good question. Not a lot of humanities people disclose. They don't, I think sometimes they don't feel like they are inventing things. Um, but it is just as important as something that's scientific. Um, and I think that, at least in my experience, I've seen it still goes the same way. We try to make the arguments we should retain ownership in it, or why we shouldn't. I I think that, with the federal funding situation the way it is, that industry right now has the upper hand, unfortunately. So if a lot of the universities now are relying on, or trying harder, to get funding from industry, and they really are able to say, well, they know your situation, and now you're coming to us and you want money. So if you invent something, we're going to own it. I mean, they have the ability to push back a little more now. Um, Not the best situation to be in, but that's where we're at. Anything else? I hope that I have enlightened you at least somewhat on how to handle IP in your and when you're looking at grants. I think I have my contact information here. If you have any questions that come up, after the fact, I'm happy to answer.
Thank you, Michelle, for your presentation. And just so everyone knows, the presentation will be available on Canvas and the recording will be available online as well.
All right, and you can thank me for giving you an hour back on a Friday.
Thank you.
All right, thank you, everyone. Have a good weekend.
You too.
Bye now.
Bye.